Larry. Thank you very much. And we're doing this a little bit differently because we're very fortunate to have Brian on the screen. So the slides you will find on your iPad if you've downloaded them. I'll try to reference. I don't actually need to use this. Everybody's got to move the slides on their own. So we'll try to reference the slide numbers as we go along. But Brian, thank you very much for joining us virtually. You'll see that your first slide is a slide of virtual reality, part of the amusement theme of the conference. And so if you're not amused by the theme, you can say that in your comments when you submit your reviews. So we're going to talk about the debate of the digital economy, where we are right now. And that debate really has been, I would say, raging for at least 4 years now, but you could even trace discussions back further then. But over the last 4 years, we've seen a lot of focus on taxation of the digital economy. I think the journey really began in earnest with the initiation of the BEPS project and the BEPS initiative. In large part, the impetus for that initiative was concerns about whether or not the current international tax rules and standards remain fit for purpose in an economy that was increasingly relying on digital ways of doing business. But in the discussions of that initial BEPS initiative and the 15 items on the action plan, they had action one was to address the challenges of the digital economy. And the outcome of that action item was a report that concluded, look, the digital economy can't and shouldn't be ring-fenced because the digital economy is the economy. They concluded that a number of the other items in the action plan, including changes to the rules on the transfer pricing guidelines, expansion of the rules for determining whether you have a PE, the recommendations to tighten CFC rules, that all of those elements of recommendations in the BEPS plan would address a number of the concerns that were being presented with respect to the digital economy, and that the plan was to continue to study the issue, that the task force on the digital economy would continue to study the issues and evaluate outcomes. Within a year of that final report, the mood shifted, and there was an increased focus on, no, that may not be enough, we need to do something. So let me start with Brad. What changed? What caused, walk us through that journey, and what do you think changed over the time when BEPS concluded that we should hold off, and what's happened now?
Sure, yeah, I think it is an interesting journey kind of walking through that. As you indicated, Manal, there were signs of where we are today that we could find in the original Action 1 report. Right, there was some discussion in that original report back in 2015 that there was some concern about this jurisdiction to tax issue. That was certainly raised as one of the items that had come up during that original report. And of course, there was the issue that was raised about a lot of the things we're talking about now, value of data and markets and things like that. So it was always there, and I think interesting, as Jesse's pointed out many times, right, that even where we ended up in the BEPS process overall about coming out with with what we all know as DEMPE now, right? It was always the DEMPE concept and where value is created, always kind of leaving open this, well, is that and where value is created something different than DEMPE, right? So it's always kind of there, and I think what we see with, in fact, if we could advance to slide 59, as you see here on that slide, right, it really kind of illustrates a lot of the underlying issues that have driven the political will to push forward what we see with the digital tax developments. And I think the quote that if you can see that on your slide here, from Bruno Le Maire is really interesting, right? Because he highlights the French finance minister where the French is going with their digital services tax, explaining why, at least in the French Treasury's mind, this makes sense. And it really, as he puts out here, right, that companies make considerable profits thanks to French customers, thanks to the French market, and they don't pay their fair share of tax. And I think that quote, is very instructive in terms of the political undercurrents that's pushing this discussion around digital taxation. And that is that it's less about the physical presence that you have in our market. It's more about the fact that there's a perception by proponents here that the market itself is driving value in some way, and that needs to be captured in terms of where companies pay tax.
Yep.
And I think as you advance to the next slide, slide 57, or pardon me, what is that one? 57, yes. Here we have just a quick snapshot of the various digital service tax measures. And of course, this is growing out of that same frustration, right, that if the global consensus international tax system, if it's not taxing this type of value creation, whether you buy into that or not, but if it's not doing that, that nations feel a need, a political imperative to move forward with something that will address that issue. And thus we see various versions of digital services taxes popping up in a number of jurisdictions. And of course, as you kind of look at that map, it's incomplete. That's just a couple weeks back, and of course we know, Australia was one that was considering that, but that's, they've kind of abandoned that at least for the moment. But on the flip side, we see Mexico announcing, right, that they're on board with this. Austria recently, right, with a 5% digital services tax that they're moving forward, et cetera. So this continues to be something that we see, and I think is evidence of the fact that, again, this underlying current of the dissatisfaction with the current international tax system. And so if you advance to the next slide, I think another point just along this journey that's useful to think about in context is a little bit of discussion over the evolution of the arm's length principle over the last couple of years. And as you think back, 5 years ago, I think it was pretty much generally accepted from an international tax perspective that that contractual rights and ownership of intangible property was really the largest driver in terms of really deciding where global international tax profits were allocated amongst legal entities, and we still respected legal entities, et cetera, through transfer pricing, et cetera. And you've kind of seen an evolution that maybe people matter a lot more than contracts used to matter. And as you look through that evolution, certainly with the C/C reporting that came out, which certainly shines a light on on people and capital and other elements where you might think about how value is created. Moving forward to the OECD outcome under actions 8 through 10 and transfer pricing, adopting this concept of DEMPI, which seems to again push the view that you need some people and substance to support those contractual arrangements. The contractual arrangements on their own really are insufficient. We saw, I think, as some of the earlier panels had mentioned, on the state aid side, taking even more of a push toward people, and some of those cases specifically ignoring companies that had solely contractual rights and essentially reallocating profits to where people were. As you move forward with that, certainly what we see in the digital services tax going at that issue, and then lastly the OECD consultation, which my colleagues here will talk more about. But you look into that paper, one of the interesting things in there, I think, is a very specific call out to the view that in one of the proposals under Pillar 1, right, which is a dissatisfaction by some countries that it's too easy under the DEMPI standard in the context of marketing intangibles to have oversight by a few people in a let's say what it is, right, in a low tax jurisdiction in the marketing space, and that it's just too easy to have that kind of oversight in the marketing intangible space. And so an allocation of income where that oversight exists is probably not the right answer. So calling out that specific issue in the consultation paper, which I think just illustrates this journey we've had over the last couple of years of a de-emphasis on contractual rights, even though that's still important, and more of an emphasis on what people are doing and where they do it. So I think, Manal, those are the things I think are interesting about the journey as we think about now where it's going to go. If we advance to, slide 59, we have some pie charts here that, hopefully they kind of illustrate the point, and I'll kind of at least close the review of the journey with this one. As we look ahead, what we're trying to illustrate on this slide is that the facts of the business doesn't change an awful lot. We might argue that how businesses are adding value, and their value change is changing pretty significantly in a digital world. But where the people are and what they do is probably going to be driven much more by the business than by tax. And historically, as we look at pre-BEPS, as the kind of the pie charts intend to show here, that there were a number of structures where we had minimal substance but some heavy contractual rights, and a lot of profit was allocated there. As we moved into BEPS and kind of closed that out, less and less, right, we have profits that were allocated to jurisdictions with minimal substance. And a lot of that IP was onshored, right, to headquarters jurisdictions. The slide, not to pick on any particular company or issue or country, but it shows Ireland, right, just as an example of where a lot of the IP might have been onshored. And so post-BEPS 1, a lot of profit could be allocated to that headquarters company. BEPS 2 is really about, well, that's fine. That may be where a lot of the contractual rights are and a lot of the oversight, but the markets matter. And so we look at BEPS 2.0, the result of that might very well be a narrowing of the quantum of profits that are allocable to a headquarters jurisdiction and some form of reallocation of those profits to the market. And so I think it's interesting as you think about it, if the facts stay the same, you see that evolution between pre-BEPS, BEPS 1.0, and BEPS 2.0.
Well, that's great. It's interesting to me that we often now talk about BEPS 1 and we're giving it these tags, and this new phase is BEPS 2, but as if it's been around, it was designed, it was implemented, we looked at the results and countries weren't satisfied, and so we're back at the drawing table. But in fact, with the final reports coming out in 2015, and before you had countries had an opportunity to then design implementing legislation, we're just beginning to see laws that were adopted inspired by or following the recommendations of BEPS 1 just now. And you can't, it's hard to say that BEPS 1 had no impact given the widespread adoption of so many of the recommendations, widespread adoption of country-by-country reporting. The anti-hybrid rules were picked up in the ATAD in the European Union, in the US reform, picked up a lot of what was in those hybrid recommendations. The MLI, the multilateral instrument to change treaty provisions, has close to 80 signatories, and a number of those treaties now just coming into force. So the question for you, Brian, is given that we have seen actually BEPS 1.0 lead to a number of both legislative changes as well as behavioral shifts among companies, what's your view? Give us some context as to why that wasn't enough for countries sitting around the table. Why were they not willing to kind of see it through before there was a decision to sort of see if we needed more to happen to satisfy concerns about both market jurisdictions as well as profit shifting?
Sure, and I think there are a couple of factors at play in what we're seeing right now. One of those is just simply the fact of a lack of availability of measurable outcomes. I mean, you refer to behavioral changes by corporations and legislation, and some of that can be seen, but it's not quantifiable. Certainly not at this point in terms of empirical outcomes as far as how tax is allocated among countries. And that's just because in part, not enough time has passed, maybe also in part, that kind of data just doesn't exist and won't ever exist. And so that is one challenge to the stability of the BEPS 1.0 settlement. I think another big issue, and maybe even really overriding issue, is just the fact of domestic political pressures in countries around the world, and that is very visible in the digital tax space, where mainly U.S. digital companies are very much part of the public conversation in countries around the world, and are associated with an idea that, well, these companies are in our market, are interacting with consumers and users here, but aren't, as Bruno Le Maire suggests, paying their fair share of taxes. Now, we could and do dispute the assertion that this class of companies is systematically not paying enough tax or is paying a different amount of tax overall than other industries. We don't think that's accurate, but this ultimately, is a matter of public perception rather than measurable outcomes. And as I said, these outcomes are hard to measure. I think related to public perception too is the fact that the debate has shifted in large part, in part because of U.S. tax reform, but the debate has shifted from a debate about the extent to which companies are able to achieve low or no tax outcomes around the world, which was very much the focus of BEPS 1.0, to a debate about what is the proper allocation of taxing rights without regard to tax rates. And here I think the public conversation has really shifted to an idea that companies, digital and other companies, particularly highly visible consumer brands or the owners of those brands, should be paying something in places where they are visibly doing business, either through interacting with users or through marketing campaigns, for instance, where they're reaching out to consumers in a jurisdiction. In those cases, there is a strong sense by kind of populations generally, but political leaders in particular, that a certain amount of tax is due in those situations in the market country or the user country without regard to where the income is taxed, whether it's taxed in the U.S. under GILTI now, or elsewhere. That is not the deciding factor anymore. So that is a big shift from BEPS 1.0 to where we are now, with countries just feeling like there needs to be a shift in the allocation of taxing rights.
So I think, Brian, certainly at the very beginning of BEPS, that notion of trying to reallocate taxing rights between jurisdictions was intended to be sort of put on the side, and the focus was, do the rules allow companies to, within the context of those rules, move profits to places where they pay no tax at all? And so the concern was, tightening the rules to deal with double non-taxation and profit shifting. And to the extent the conversation veered in other directions, I think everybody brought it back to, no, our focus now is simply about profit shifting and not about reallocating. But that's a much larger undertaking to reallocate taxing rights. So Jesse and Jeff, you were both in the OECD Secretariat during some of the discussions and the working through the recommendations coming out of BEPS. Could you have seen this coming? Was there enough pressure building that countries weren't satisfied about limiting the discussion to addressing profit shifting versus actually renegotiating the original agreement?
Yeah, I mean, you saw some creep in that mission from the very beginning. Action 1 semi-explicitly talked about broader challenges of the digital economy that went beyond the mere BEPS issues, and looking back at that time, it was Action 1 for a reason. It was Action 1 because people were feeling political pressure to prioritize it, and they insisted that it be Action 1. It was given a 1-year deadline, which was ludicrous, but also was because people were feeling political pressure. It ended up being extended to a two-year deadline, at the end of which the conclusion was, look, we've got BEPS measures, they're going to need time to do their work, but we're going to come back to this debate on the broader tax challenges. Even getting to the idea that we'll come back in 2020 with additional work. That was a hard-fought compromise, fighting past ideas of like interim reports every year. In the meantime, with the notion that actually doing all of this work on really tight timeframes doesn't lead to better answers; it leads to worse answers. But you could tell the push was going to come. And sure enough, it did, and all of the timelines got accelerated, and everyone wants answers now. Not clear that that's a great approach, but the pressure has been there from the very beginning.
Jeff, any other thoughts?
Yeah, well, I arrived a little later than Jesse's time at the OECD, and to me, it was not at all inevitable that we would end up, here in 2019 talking about allocation of profits, and slicing up the pie differently, like your charts. I think I saw the pressure in the digital Action 1 really more focused on nexus and PE definitions and remote sales that through the internet could achieve a significance that catalog sales and telephone sales in the past could never achieve. And as recently as, I can't remember when the IFA conference in Rio was, but Professor Rosenblum and I were on a panel there that was noodling about the digital stuff, and we both kind of said, well, yeah, we understand there's a PE question here, but why are people talking about changing allocation of profits all of a sudden? And so to me, it was a big surprise. And I think to a lot of people it was a big surprise when U.S. Treasury said, oh, we've got an idea for, marketing intangibles. I said, oh, okay, interesting, but that's quite different, and it's broad, and it kind of changes the whole discussion. Remember, the interim report, so even after that, there was an interim report a little more than a year ago in March 2018 that said there's three groups. We don't have agreement here. There's one sort of limited proposal for just, user contributions, looking at value creation through user contributions. There's the marketing intangibles proposal, and then there's a bunch of countries that don't want to do anything yet. They want to wait and see. Somehow between March 2018 and January 2019, that third group is no longer on the radar screen. Right. It's like, oh, we got to do something. Here's a bunch of proposals. Yeah. So to me, it's been a surprise.
What's interesting is it's obviously that the sense of urgency to get something done corresponded with the significant political pressure. Brian, you referred to it. It's very palpable in the fact that we are seeing digital services taxes, unilateral digital services taxes being adopted in many jurisdictions that are gross basis taxes that don't seem to take into account, well, how are you going to relieve double taxation? How do they fit within the existing system? And so what you see the OECD doing is catching up with what is happening as a result of political pressures. And we saw that in BEPS 1.0, frankly, that the timeline with the BEPS initiative in and of itself, which was very aggressive, was driven by the fact that there was significant pressures that countries were going to act unilaterally if there wasn't some sort of consensus solution. It feels like the pressures now are even more significant. I think initially there was some waiting that happened with BEPS 1.0. There are a few things that came up, DPT and et cetera, but now you have a really an acceleration of unilateral measures. So let's talk about the OECD consultation paper, the most recent paper, what it's trying to do in terms of stemming the tide and getting back to consensus. Let's see, Jeff, why don't you give us an overview? And for those following on their slides, it's slide 60, just an overview of the two pillars of the current proposal of the OECD.
So yeah, end of January this year, OECD Secretariat, following the inclusive framework plenary meetings in Paris at the end of late January, put out a very short policy note that described very briefly proposals under, I still get a little confused about being under two pillars, because pillars are things that things stand on top of. But anyway, so we've got a, right? I think it's more under two kind of headings. Anyway, pillar one, and then there was a consultation document 2 weeks later in mid-February that gave more detail, although not full details by any means on these proposals. Pillar 1, for those of you who aren't familiar, has 3 proposals having to do with nexus and allocation of profits. Most of them focus more on the allocation of profits piece. The first one was advanced by the UK and is limited to what they think of as the digital economy, and it tracks their own digital services tax proposal. It only applies to social media companies, search engine-based businesses, and so-called online marketplaces like Airbnb, et cetera. And that is, in their view, getting at the problem, which they think is value creation through, excuse me, the contribution of data by users. And they think in the current tax system that's not accounted for in the transfer pricing rules, and they want to tax that. The marketing intangibles proposal, which the US has led, says, no, we don't think you can ring fence it to those defined classes of businesses. We think it makes more sense to say, there's a market, there may be now remote sellers who can really compete in that market, but they've got marketing intangibles that we can deem to be located in that market and have profits attributed to them. Traditional full facts and circumstances transfer pricing may be too difficult, so we're willing to talk about some more simplified formulaic approach to that. The third one was advanced at the last minute by India and a group of 23 other countries, which includes some very large and vocal countries in the inclusive framework discussion, including some that clearly don't like to be pushed around by the G7. Brazil, for example, South Africa, Argentina's in there, Mexico is in there, which is an OECD country. So their proposal is the kind of India version of a virtual PE, significant economic presence, based on some sales or user number threshold, plus something more. And they sort of list some possible plus factors, such as a website in the local language, or receiving payments in local currency, or targeted marketing to the local market. And that is not really very fleshed out at all in the consultation document, and didn't attract a lot of a comment, other than the fact that its apportionment or allocation method is strictly formulary. They call it fractional, but it's what we all think of as global formulary apportionment, and they're very open about that.
Yep.
So that's Pillar 1, those 3 proposals.
Okay. Jesse, you want to cover Pillar 2?
Sure. Pillar 2 is really, this is where BEPS 2.0 falls. One might ask up front, what does this have to do with the digital economy? It's looking at shoring up low tax income. The answer is nothing. There isn't really much of a connection to the digital economy work, other than some folks who had some enthusiasm for some of the Pillar 1 ideas lost a bit of that enthusiasm and thought that a Pillar 2 approach might accomplish what they want to accomplish. It's now tied up in all that work, seems to be an essential part of the package going forward. So the idea is a minimum tax, not unlike GILTI in concept, applied by all countries participating with respect to income that's taxed below a certain threshold. The idea seems to be, as a previous panel had mentioned, that we're looking at a country-by-country version of GILTI, as opposed to looking at overall blended rate for determining whether income is low taxed. How that's measured, very much up for grabs. We'll talk more about that later. But the thing that separates this from a GILTI-style regime is that it's accompanied by what has been described in the past as a BEAT-style regime. That's a very scary way to frame it. It's not really that. But the idea would be that source countries, market countries, would have the ability to impose tax on outbound deductible payments that are not subject to sufficient levels of tax. How that works still very much under discussion. So a couple of options suggested, not totally clear from the paper actually whether they were options or things that would apply jointly, but either denial of deduction or potentially withholding tax, or denial of treaty benefits as options to consider. All of those sound a little scary. And some of the harder questions are left unanswered. But that's broadly what the proposal is a combination of source country and residence country measures, similar to how the anti-hybrid rules worked, with the goal of addressing what are perceived as continuing problems that BEPS 1.0 didn't solve.
It is interesting because often that component, the anti-base erosion component of Pillar 2 is compared to the U.S. BEAT. But of course, in the U.S. BEAT, the rules are looking to whether you've paid enough, a minimum tax level within the U.S. with and without the deductible payments. So it's really about whether the base eroding payments are reducing or eroding the U.S. tax base, whereas the proposal that is showing up right now in the OECD consultation compares the amount of tax you're paying, how much tax is imposed on the income side of that deductible payment. So they're looking outside. So very, very different points of comparison. So Brian, we know that Pillar 1 is really this new look, the shifting of the allocation of taxing rights between jurisdiction. Pillar 2 seems to be a continuation of tightening what started in BEPS. What is the U.S. perspective on these, particularly in Pillar 1, on the various proposals? We know that the marketing intangibles one originated with the U.S. And then also, to what extent is doing something in the Pillar 2 space, effectively adopting extensions of what the U.S. has done with GILTI or some anti-base erosion measure necessary for consensus? Can you get consensus without Pillar 2? Do we need both, or is getting Pillar 1 going to be sufficient for countries?
Yes. On the first question about kind of our perspective on the work on Pillar 1, I mean, obviously, with regard to the user contribution proposal, we've been perfectly clear that we don't think this is the principled or practical way forward, trying to distinguish between digital and non-digital or based on user contribution or data. So that we see as a non-starter. The significant economic presence proposal is basically a dramatic replacement of the existing system, which, aside from the fact that the proposal isn't well specified, is pretty vague as to its details right now. Even if it were better specified, I think it would carry tremendous risks from the perspective of just putting all of your eggs in one basket. We're going to entirely reform the current rules for allocating taxing rights, moving away from arm's length principle into some completely formulary replacement. Just seems implausible, not to say politically unlikely to get consensus. So that leaves kind of the marketing intangible idea. And here, what we're thinking in terms of the marketing intangible idea, we're thinking of it as a principle or a concept that could inform the development of a specific proposal. This idea that the income associated with marketing intangibles can be thought of as closely related to particular market jurisdictions in a way that might justify thinking about allocating taxing rights in a different way, in particular allocating taxing rights over that kind of income to the market jurisdictions. But that's a concept or a principle, and principle is very important in this discussion. I think countries are very leery of just striking a deal, rightly feeling that would not lead to a stable outcome in the long run if the deal were not based on a principle. That said, I think there is a real tension under Pillar 1 and the proposals that are being developed there between principle and closely tying the proposal to principle. In this case, the idea of marketing intangibles, and doing something that is reasonably administrable and simple. And I think there really is a direct trade-off between those things. You can go more in the direction of administrable and simple, which everybody insists is very important as well, but then you are less closely tied to this principle of trying to, for instance, identify the return associated with marketing intangibles in some precise way and allocating that to the marketing jurisdiction. So we're going to continue to struggle with those competing goals of simplicity and adhering to principle. But I think the most likely outcome is something motivated by marketing intangibles, but a little bit more in the formulaic direction. How formulaic and how many bells and whistles there are in the formula to get back closer to what you would get with an assumption that marketing intangibles exist in the marketing jurisdiction, and then just applying the arm's length principle, we'll see. But that is, I think, the direction that Pillar 1 is heading. And then to the question about Pillar 2, is it necessary as part of a consensus? I think that it is necessary as part of a consensus, and that just because some key players in that potential consensus view the work under the second pillar as an essential part of this work, and I think there's nothing more than that. I think it is valuable work, and I think it is a positive thing to have other countries subject to minimum tax rules as our own companies are subject to the GILTI regime, but the political reality is that this will have to be, I think, a two-pillar consensus.
Yeah. So I guess related to that, in some of the discussions I had when I was at the consultation, there's often a lot of focus on Pillar 1, and I suppose because it's new, there's all of the proposals under Pillar 1 suggests that there's going to be a departure from the arm's length standard, so you have to come up with a concept to replace that. And that yet, when you talk to Pillar 2, there's a sense that, well, that's easier. It's modeled a little bit after the US reform rules, and so a couple of times I've heard folks say, well, that's easier. From my perspective, I think it's quite complicated. And when you think, I talked about the difference between BEAT and what's being proposed in Pillar 2. There are differences between suggesting a minimum tax and what GILTI, the way that GILTI operates today. On the earlier panel, there was a discussion about that and the relevance of the foreign tax credit. Going to a per country regime would be very different. There are questions about attribution rules and how do you determine ownership and so forth. So there's a fair amount of work and the devil in the details in that Pillar 2 if you were actually going to reach consensus on approaches. So maybe two questions for you there. One is, to what extent, in order for Pillar 2 to be successful, is consensus defined as including having rules that are the same across all of these detailed things, like is it a min tax or is it more GILTI-like? Do we have the same foreign tax credit mechanisms, same expense allocation rules, or will it be a looser consensus? So that's number one. And then number two, what is the Treasury's perspective and willingness or appetite to change US rules that have the newly minted US rules to adapt to a consensus at the OECD on things like a minimum tax or a redefined base erosion rule? And then obviously, what is the appetite of Congress for that?
Yeah, on the first question about the nature of the consensus, how detailed that that agreement would be, or whether it be a looser consensus. I think it is likely to be somewhere in the middle. I mean, it probably tending towards looser consensus, and not being highly prescriptive about how you implement the basic goal of achieving a minimum tax rate. Now, I think that there are a lot of key design questions that will have to be part of that consensus. Like for instance, the issue of whether you are topping up to the minimum rate or you're topping up to the country's headline rate. I mean, that is a fundamental issue. Also, the basis on which you're measuring whether your effective tax rate is meeting the minimum rate or not. That is it a global measurement of the effective tax rate, a country by country, or some other level of aggregation? I think that could be something that is part of the outcome as well, but many of the other design details might not be part of any standard that comes out of the OECD. But at this stage, it's really too early to tell. We're at this stage trying to get a sense of where different countries are at. And on this pillar, I think there's just a lot of technical work that needs to be done to determine feasibility that will inform countries' views to technical work related to the design of the income inclusion rule, but even more so maybe on the base eroding payment or undertaxed payment rules as well, and the coordination of the two regimes. So too early, I think, to say what exactly the level of detail is that the outcome will adopt. On the second question about U.S. appetite to change the rules, I think I won't presume to speak for Congress, and it's too early to know, whether and to what extent outcome under Pillar 2 is going to differ from what we already have, how much the income inclusion rule would differ from the GILTI regime. But I think we can take as instructive the fact that Congress has in fact legislated even recently on the basis of a detailed consensus agreed at the OECD. That in the context of the 2017 tax reform, Congress did implement rules that look very much like and are consistent with the interest deduction limitation rules, the anti-hybrid rules, as well as arguably consistent or inspired by the CFC rules that came out of the BEPS project. So there is precedent for Congress legislating based on an agreement at the OECD, and we're also encouraged by the various expressions of support that we have received from congressional leaders for our participation in this process.
Yeah, and there is a slide there that quotes some recent congressional statements in support of following a consensus. And it is interesting, it's a little bit of a shift in the way things are done, is to follow the detailed work that's happening at the OECD and then see it show up in US legislation. That traditionally hasn't been the way things went, and we saw that in the hybrids, we saw it in the interest limitation, as you said, Brian, and maybe now we're seeing it in revisions to the min tax or the base erosion rules. So Jesse and Brett, what do you see are the main challenges of these pillars? Either one can start.
Well, maybe I'll just throw out a few. I know we want to leave some time for questions, but just a few on Pillar 1, and my colleagues can talk maybe about Pillar 2. I think Brian mentioned a couple of them there, right? Which is, really you have the basic issue of how do you get to consensus. Probably, looks like something along marketing might be the leading piece, but you probably have to blend the needs and desires of some of the other countries put forward some of these proposals to get something that emerges there, right? But assuming you're kind of moving along the lines of marketing intangibles that Brian mentioned, right? You've got this issue of do you do it more disciplined and complex, right? And so as you move away from transactional transfer pricing as we've historically known it between legal entities, and you do some type of global profit split, but it's more disciplined and you feel more comfortable that you're actually getting at true marketing intangibles. Well, that's complex to begin with, but it has some simplicity in that you think you now have identified marketing intangibles, and presumably you know where those were booked on a legal entity basis, because at the end of the day, we can't double tax. If we're going to tax some of our profits on a global basis, we need to allocate some kind of deduction or exemption back to the legal entities that contributed into that global pool. Well, if you know what you measured in the first perspective, you have a better shot of being able to push that deduction or exemption back to the legal entities that contributed to the pool. Well, if you go simple on the other side, right, some percentage of sales is adjusted by some levers, et cetera, you may capture marketing intangibles profit, or you may capture something else, or less than all marketing intangibles. So how do you push that back to the legal entities, right? And I think that the same issue comes back to the taxes that are paid on a global basis. Presumably those need to be allocated back to legal entities as well, some kind of US style, technical taxpayer type rule, even though it's paid by one member of the global group, right? And that may matter for Pillar 2, right? If if the taxes get pushed back to an entity, do we count them for purposes of whether that country or that entity is a low taxed entity? Presumably you would. So I think all these things create some really interesting detail issues, and not to mention the issue of losses, right? What if we have residual losses? How do you deal with those? So we could go on and on, but those are a few I think that stand out to me.
Yep. Jesse?
Yeah, I mean, losses also figure into hard questions in Pillar 2 when you're trying to determine who's low taxed and who isn't. How do you measure that, and over what time period, taking into account carry forwards of losses and things like that. You have hard questions about interactions between the two. I think a proposal that is put forward frequently is that with respect to the source country rule, you probably ought to just turn it off if it's being paid to an entity that's going to be subject to an income inclusion rule in its ultimate parent jurisdiction. Who decides, what's an appropriate income inclusion rule? What are the criteria for that? And is that the right answer? These are all hard questions. You have a lot of push from folks for applying a global type rate to determine whether you're low tax or not, rather than country by country for the sake of simplicity. Think about that from a source country perspective. Are they really going to sign on to an approach that says, yeah, sure, my payment is coming out of my country and it's going into a country where it is low tax, but some other payment in some other entity in some other country was high tax. So is that really good enough for me from a market country perspective? These are all hard questions to get to a good set of answers. The sort of second set is, what are you really trying to accomplish with that source country rule? Is it just a stick to get people into the residence country rule? If that's the case, the design looks a lot different than if the goal is to allow market countries to collect a minimum tax on an ongoing basis. So not an easy set of issues to work through.
And a very aggressive timeline. Why don't we see, I know, Jeff, you were going to talk about business implications, but maybe take a question to see if there's any questions from the audience before. Okay, that makes it easy. We'll use up the time. So question on business impacts. What are we seeing? And then, Brian, I'll come to you to finish it off and talk about how businesses should engage and what we can expect in June.
Obviously, I think multinationals are very concerned about what may come out of this. It's a serious risk of double or multiple taxation if you're talking about, kind of giving a green light to certain countries that want to attract more taxable profit to their large populations. Mm-hmm. Other countries that may have much smaller populations but have exporting businesses may not want to get on board with this. And the likelihood that you get agreement among everybody on harmonized tax rules in a world of sovereign countries you know, that there's nothing in history to suggest that everybody's going to
Yeah.
sing from the same song sheet.
Though there was an agreement on a number of things, you know,
BEPS.
for a long time, or even before BEPS, you know.
Well,
the
yeah,
fact
no,
that
we
had
have
treaties, we had the
Well,
arms.
exactly. I mean,
Yeah,
so
yeah.
that's another worry, right? We have, despite the fact that, you know, multinationals have, you know, to deal with uncertainty and international tax, there still is, you know, a system that, despite the unilateral DSTs that have been coming up, overall, you know, it's still a reasonably stable system. And so I think there's a real concern about what will be the result of upheaval. And tax reform, you know, BEPS was like, okay, we want to stop the shifting of profits to havens. And all the countries that agreed on the BEPS minimum standards had a common interest in that. Here, it's much more like tax reform in a domestic context where there's winners and losers and there's political fights, and somehow, you know, if you have a majority, as the Republicans did in 2017, you can get it done. And there's a government that can enforce that. There's no global government that can enforce some tax reform deal.
Yeah.
So, you know, the likelihood that all the countries of the world are actually going to agree to some nice magic bullet formula that all the businesses can rely on, I think is unrealistic.
So Brian, final word. I know we've run out of time, but a final word on, so June is the report. I'm sorry, I keep looking up there. I'm not sure whether to look at you here or there, but what should we expect in June? Will there be a magic bullet in that final report? And will it be enough to, we heard the French finance minister say they're very in favor of a consensus solution at the OECD, and they're willing to drop the DST if there is that consensus solution, but only if it captures data. So we're seeing people sort of throw the gauntlet down. What should we expect in June, and will it be enough?
I think the goal for June is a detailed work plan for carrying forward the work between June and the end of 2020. I don't know yet how much that work plan will narrow down the options from, in particular under Pillar 1, about what form a particular proposal would take. We're still having those discussions right now. There's an intensive period of work where the steering group of the inclusive framework, which is a smaller set of the countries in the inclusive framework, including the United States, is working, the steering group is working closely with the Secretariat to develop that detailed work plan, which will then be presented to the inclusive framework at the end of May for discussion and approval, and to be sent ultimately to the G20 finance ministers for their meeting around June 8th. And so that's the work plan going forward. At this point, you know, it is hard to say what level of detail will be in that detailed work plan. But you know, in this period, we continue to welcome input from business stakeholders, in particular about their thoughts on design questions about what we could do under Pillar 1 and where might be a productive direction to lead the discussion.
Great. Well, thank you, Brian, very much for joining remotely. Thank you to the panelists and Larry.